LA Probate Expert, and we interview regularly probate experts, vendors, attorneys, and such, other real estate agents. And I'm excited today to have from my parents' home city, Richard Desir, who's a probate attorney in Philadelphia. Andre, how are you doing?
I'm well. Thank you for having me today. I really appreciate it.
Thanks so much. So give me a little background about you. Where'd you grow up? And then how'd you get into practice of law?
So I am originally from Queens, New York City. I went to John Bowne High School, the City College of New York, which is my father's alma mater. And then at the age of about 26, I left New York to go to law school, and I ended up at Villanova in Bryn Mawr, Pennsylvania.
I know where Bryn Mawr is. I've been there too. Oh, very nice. And so in your legal career today, are you a sole practitioner? Are you part of a firm, or how do you practice law today?
So I currently clerk in the Philadelphia's Orphans Court, which handles all probate matters. So I advise two judges. I get all the initial filings, all the documents, I review them and submit them to the judge. And for their recommendation, I make a recommendation and they make their final judgment on each and everything that passes through the court. I stumbled into the practice actually by accident in law school. One of my summers, I had met a judge, a fascinating woman. Her name is Cheryl Austin. Judge Austin is a probate judge, and I wanted to work for her. She was a captain in the Navy, just an all-around admirable woman, and I ended up externing for her during my last year of law school, and then I kind of sort of just learned all about probate, and I was like, okay, I want to be a practitioner in this field, in this space. And then she connected me with some of her colleagues, and I ended up landing a position as a clerk in Philadelphia's Orphans Court.
And so when you say the title clerk, are you a member of the bar?
Yeah, I'm a member of the Pennsylvania Bar.
So the clerk just means that's your position, that you support the judges.
Yeah. It's very funny because to non-lawyers having to explain what a clerk is, it sounds a remedial and like an administrative role, whereas
Right.
All lawyers know that it's actually a very prestigious position. You have the ear of the judges. You are the first line of defense, and you can, I think, sway or have a lot of impact in the way decisions are made. It's come to people's attention now, most recently, because of the leak in the Supreme Court. A lot of people think it was a clerk, one of the justices' clerks that do it. So the Supreme Court justices each have about 3 clerks, whereas in your average judge has 1 clerk and a couple tip staff.
Now, in LA County, your position is titled the probate attorney. And so people mistakenly will talk about the probate attorney, and you don't really know it. Do you mean the family's hired, counselor, or do you mean the attorney that clerks for the judge? But they do use the term in LA County probate attorney, and I think it more, to the layperson, I think gives more prestige to the position. That really, I think, in LA, not to diminish the judges, but they couldn't possibly review cases without the probate attorney reviewing the nuts and bolts, the details, and the documents.
No, the amount of filings that court receives is voluminous, right? Every case has 300-400 pieces of paper sometimes attached to it, and my initial job and is to go through it and make sure that all of the rules are being followed and adhered to, and there's not missing any documents. So from just a purely administrative aspect, I do that. But then there's also a legal aspect to it, right? So I see if their notice has been sufficient, right? One of the cornerstones of the law is notice. So I want to see if this is the first filing, how did you notify the other parties? Did you follow the rules of the law? And if you didn't, well, then that's a primary matter. And we can't even get into the substance if you didn't follow the procedure correctly.
Right. And I think oftentimes pre-COVID, I would go to court every day and watch the morning calendar. Now, LA is the largest probate court in the country. We had about, I think back then, maybe 9 or 10 different departments that did probate. I would sit in different ones daily. And customers, the families or the petitioners didn't understand that it's not that the judge was being mean by saying, no, you didn't notice this other error. It's that really it's not fair. Like the rules of the game are such that you got to give people a chance. If you didn't give people a chance, then we run the risk of there being fraud, right?
Right. And I think it's interesting that you bring up LA County. And one thing I wanted to talk about or just reference was Chadwick Bosewick's estate. And I wasn't sure if it was in LA. Was that an LA County matter?
I think it is. I know he is as an actor. I can't say I've followed his I will say I followed Britney Spears' case because whenever that came up, there'd be protests outside the courthouse. So you had to know when that would be so you could avoid parking and all that kind of stuff. Um, his case, I don't think has quite got the same physical attention.
I- for me, it was just alarming because I was like, this is an Avenger, right? Like, and then he didn't have a will. Like an Avenger didn't have a will. It was like I couldn't even. I was stunned when I saw the word intestate, which means you passed without a will. I was like, the Black Panther, like no one, you know what I mean, told the Avenger he needed to have a will. And especially if he saw his impending doom, right? It wasn't as if it was it came up all of a sudden. The gentleman, I believe, had serious medical conditions and understood that death was imminent.
Oh, wow.
Yeah.
Well, I mean, I'll give you a worse case, I think, is Michael Jackson. I mean, how many attorneys did he employ in his career? And Chad Boseman, I don't know as much about. Some Black Panther, younger, right? Michael Jackson had this long career from when he was like, 8 years old, 50-year career, 40-year career, whatever it was, with teams of attorneys, and nobody ever said, hey, Michael, you might think about getting an estate plan. Like nobody, they all made millions of dollars off of him. Not one person thought about that. And so when I talk to customers who are hesitant, I have to understand even Michael Jackson, didn't prepare for that. Or Prince is another one.
Yeah, I being in this area of the law is so interesting because even other attorneys, I run across so many other attorneys who don't have wills.
Yeah.
And it's just, I don't know if it's because of the morbid nature of it, but, we don't talk enough about the importance of having a will. And I have a funny or interesting anecdote. My grandmother passed away recently in Florida, and I went there for the funeral. She was 86 years old. Again, another one had serious medical conditions, and we, her, I think death to her, we saw it coming. And she didn't have a will. And my mom has 4 siblings, and all of them currently are it's very contentious about just pieces of jewelry, like not even things or that matter very much or that are very expensive or valuable, but they matter to the aunts that like this one wants the ring, this one wants the Pandora bracelet, right? There is a lot of contention about even the smallest items. And, a funeral just happened. So it's not the best time, things charge people a lot of emotions. It's not the best time for cool heads to prevail, so to speak. And I think that's where a will does a benefit to, your heirs, not only in your disposing in the way that you want, but it avoids, my aunts are fighting now, right? Like if I think my grandmother had a will, they wouldn't be fighting.
Right. And I think definitely, obviously didn't meet your grandmother, but in general, I think if the decedent saw the aftermath of the lack of planning, and I think you might talk about emotional fighting, and there's money fighting. There's people who save their whole lives and have a couple $1 million, and it all ends up in attorney's fees and court costs, and they're fighting each other. No doubt, if you go back in time and look at that going on, I guess forward in time, you would make the decision to prepare, but it's challenging. And I'm a real estate agent. I don't really make money doing estate planning. I refer to attorneys and services, but I talk about it all the time. It's so important to avoid probate court if you can. Not that you're not a nice guy, not that your judges aren't nice judges, but nobody wants to go into your court. Nobody comes out, I think, better off for having been there.
I think I agree with you, and especially an interesting thing about probate court, unlike other courts, it's one of the last court of equities left in America or in our judicial system. So it operates a little differently than I think like a criminal court or a civil court, right? The court is designed for judges have broad discretion. There typically are not jury trials, right? So you are at the mercy of a judge in that regard. So yeah, I completely agree with you that going to probate court is something that people want to avoid if necessary.
I always tell people the judge can do whatever they want. Now they may not, and they follow the law, but in probate court, they have a lot of discretion. And it's interesting how I work in a couple of different counties and in different departments. And some judges will bend over backwards, say to avoid a foreclosure. Other judges will say, hey, you know what? They noticed you. They followed the law. You took a year to file the probate. Shame on you. Let the chips fall where they may. And you can do whatever you want to do between now and then. But that's not a probate issue. That's a real estate issue. So I think that it's interesting how different the judges are. How many different departments or judges do you work with? Just one judge in your business?
I'm atypical. I'm only supposed to work with one judge, but I actually happen to work with 2 judges, and that is an atypical posture and position. Typically, you only advise one judge, but you are spot on that judges have their different views and takes on the law and the behavior and their own judicial philosophy, right? Like
Yeah.
how they view like how they think about themselves as judges,
Yeah.
and that affects your case and the things that you have to do. Some judges, they don't allow late filings. Even if you're a day late,
Right.
they're
Right.
holding that against you. Some judges are a little bit more lenient. They want to see things settled on the merits rather than for procedural grounds. And you got to know what kind of knowing what kind of judge is in front of you is I think a large part of the battle as well. I wanted to you did bring up an interesting point, and I think it's relevant and germane to what you do is real estate, right? And one of the hot topics or a trend that I think is starting where like it's becoming more familiarized and normalized is putting property in trust and doing that through a will. I don't know when that paradigm shifted, but I have noticed, especially high net worth clients, or there it is starting to become a very popular mode of leaving your assets is by trust.
Well, I think like everything else, it's become, with technology, an attorney who puts time in on something can do it more efficiently and the costs have come down. And so you can, one of the services I recommend, I've interviewed on my channel, trustandwill.com. It may not be the right trust for most people, but it is the right trust for a lot of people, and they should have a trust, that particular plan in place. But and it's true that too many people create the plan, at least in California, and then don't deed the assets into the plan. And that's a whole legal quagmire that is different. So in California, for example, there's a process where if you create the legal plan, the trust, let's say, and then you don't move the property and deed it in the trust, we have a court case called Hegstead in California where there's precedent where the judges can say, well, it was their intention to, and they just didn't do the paperwork, and we'll allow that to happen, which is interesting because then what's the purpose of the deed? I mean, at some point you might say, you still have to prove that was their intention, and they'll go back and look at the trust. Does it name the property, but they never deeded it in? That's different than if they didn't name it. Why didn't they name it? So still plenty of room to argue, but better to get it in the trust. In Pennsylvania, or at least in the court use service, if they create a trust or a plan of some sort, but don't change the deeding of the property, the titling of the property, most states it's like, no, sorry, we play as it lays, right?
Yeah. It very much is where things stand, four corners, right? We're not giving people a lot of benefit of the doubt in this space. As far as what's in a trust and what's not a trust, it's very much a four corners rule that we follow. And another talking about people deeding their property and giving their making sure they dispose of their assets. Another thing I was thinking about when I was preparing for this interview was thinking about why people don't make wills or how they view wills. Is a lot of people think they don't have any assets, right? They think, oh, I don't have anything to leave anyone, so I don't need to make a will, or it's immaterial for me to make a will. And bringing up Michael Jackson or Chadwick Bosewick that we spoke about earlier, right? Their estates have interesting things. Every time Black Panther plays, his estate, gets 10 cents or whatever it is, right? And even if he's long gone, his estate still will generate income and have an interest in future things that exist in the world. And we all, right, have interesting things. And I was watching a commercial earlier for AstraZeneca or some medicine, and I'm thinking to myself, 10 years from now, when there's a giant recall for this, if you took this medication before this day, you might be entitled to a settlement, right? And thinking about the future interests that we have, and even if you have nothing now, right, and saying I leave my future interest or the residue or the remainder of my estate to X, Y, and Z person, when in the future, if something that becomes yours or of legal value arises, you now have an avenue to give it to someone rather than it just, floating in the ether. So I think that is something a lot of people aren't aware of, and that combats that notion that, like, I don't have anything. Why do I need a will, right? I don't have anything to leave anyone, right? We all, even if we're, have no money or anything of current legal value, we might have interesting things in the future.
I would see that in probate court where a common example was car accident, right? Somebody has no real assets, but their income, they're making money every month. They leave a family or whatever, they're entitled to compensation, but they're dead. What happens with the money they would receive? Well, it can go into probate, and then that's going to get torn up. Or if they have a estate plan, it goes into trust, so the trust can deal with it more efficiently. And so you're right. We all have, we don't know all the assets we might have down the road, and definitely makes sense to prepare. And then just to kind of tick off the title, make sure we're clear. So you mentioned that you're in the orphans court, but that's just the name. That also covers probate and trust litigation and related things. It's just that that's also where they deal with conservatorships and guardianships. Is that where?
Yeah. And in New York, they call it surrogates court.
Exactly. I was gonna say.
So it is just a naming, a nomenclature that different areas use to describe the court. Well, the concept or the idea is that there is an ex parte, right? There's another party that's missing, and all of these, all the matters before the court. So if it's an estate matter, right, the person has passed away, they aren't present in the proceeding. They have an interest in it, but they're not here. If it's guardianship or an incapacitated person, they can't defend themselves. So the court, all of these matters where a party is for all intents and purposes absent is the matters that come before orphans court in Philadelphia, surrogates court in New York, that those different probate courts that handle matters where a party is absent.
Same in Los Angeles, we have probate court, but the guardianships, conservatorships, and then trust litigation are handled in the probate court. It's not probate, it's related to probate or similar laws, or the rules kind of overlap and things like that. So you must then see, I imagine, filings by attorneys that are regular and by attorneys who are irregular in your orphans court. In LA County, and I've pulled the actual data, 95% of cases are done by attorneys who've done one or less in the last 12 months. And while I'm not an attorney, I know the rules, the forms, procedures, and I watch the procedures. I always think, well, how could you possibly do one efficiently if you've only done one in a year? What's it like in the courts you work in? What percentage are by attorneys that are focused on probate as a primary business? I'm not sure how you would quantify that. Those that are clearly don't know what they're doing once a year or less, versus pro per or pro se or whatever your term is.
I'd say 70-30. 70% are known practitioners, people who've appeared before the court before. There's a heavy practice here, and I would say 70% are those individuals. And we have 30% pro se lawyers who file things they have no business filing, so about 70-30, I would say, in Philadelphia.
That's pretty good for you. So only 30% are really just driving you crazy. There are 70% are more procedural and substantive issues.
It's taught me a lot, actually. It's made me, I practice law in a couple different areas as well. So like I've handled small landlord-tenant matters. I've handled car accidents. I'm doing a bankruptcy now. So I've handled other matters, and it's made me, being in my position and seeing and understanding what it is like when I have a filing from an attorney who knows the space versus who doesn't know the space. It makes me, in my own practice of law, a little bit more cautious in what I send to a court, right? Like I spend a little bit more time researching filings, just seeing what other practitioners, like the super lawyers, have filed to the court, just to make sure that I'm following form, that I am not missing a beat, because it's very easy to do that if you're not familiar with the practice. And you bring up like an excellent point, like having a practitioner that's skilled in that field will help a case move along quicker than having a lawyer who's not skilled. Not saying that a lawyer who doesn't have experience in the field can't like successfully litigate a case. It just doesn't happen as smoothly.
I agree. So are you able to also practice in probate or orphans law? No, you can't. But that's a natural, when you're done with this job at some point, is that a career path for you, or are you going to avoid that, or what's?
I mean, that's the goal for me personally, but there is a very hard and fast, like nothing to do with orphans court matters. I work for the state of Philadelphia. I'm a public servant, right? I can't, it would be totally improper for me to practice in front of the court that I work at, right? So
I don't know. I mean, as a layperson, I would say better than some of the other people I see practice law in front of that same court.
But I would file a motion and then turn around and pull it for the docket. No.
Well, no, I'm not saying that, obviously. So in Philadelphia, are there only two then circuit court that handle probate? There's two total?
Judges?
Yeah.
Oh no, there's a whole suite of 6 or 7 judges that rotate in Philadelphia alone.
So couldn't you file in front of one of those other judges, and then your colleague I guess that's the problem. It's your colleague, and yeah. But you probably would do a much better job than a bunch of them. I'm telling you, in LA County.
That's the plan. I plan to, take everything I've learned and actually use it to help Philadelphians and other people in Pennsylvania who have these issues. And these issues are serious. And I sometimes, like, when doing my work, I take a step back and I just think about it. Like, this is, the culmination of someone's life efforts or works, right? Like, what they've left behind is their legacy. And sometimes I really appreciate that. And I just look at the filings and I think about, this person had the wherewithal to, get multiple properties, to have, different streams of incomes and set up very thoughtful mechanisms to give their ancestors things. And I'm like, this person, it's a testament to their life. And so the gravity of it, sometimes it weighs on me.
I'm so often impressed by the story of a decedent where, he, World War II veteran, he and his wife bought some small house in some, the worst part of LA, but they over time paid it off, bought 2 or 3 other properties for family members, paid those off, lived a very, from outwardly looking, modest lifestyle, contributed to some organization, a church typically, and ended up passing and leaving an estate like $3-4 million. And they're driving some old car. And if you bumped into them, you would think they're not worth a nickel. And meanwhile, and they raise kids. Though the flip side is, if they don't plan for it properly, they have kids. My experience is, unfortunately, too often, who don't ever launch. The kids are staying in the family house. They never do the probate. They never, take the asset and build more wealth with it. They end up fighting with their siblings. It ends up being illegal. And I would say to myself all the time, if there, I'm a lifetime Angelino. I went to school at USC back when that was really like a ghetto school. Now it's a nice area. But it's just heartbreaking to see what's happened to so many families. If I could do one thing that would change the wealth of Central Los Angeles, it would be if every homeowner could be given a estate plan, just a simple one. Yes, it's not as good as a better one. It's better than nothing. And if I could just make that magic one happen, it would transform the wealth in that community. It would transform the experience of that community, the real estate in that community. And it just seems like such a simple fix, but nobody seems on that track. It's the opposite. I almost feel like when I would go to court, I felt like I was watching a Mexican cockfight with the two, owners of the roosters trying to get people to fight to run at the bill. It's just heartbreaking what I see in LA. Is that similar in Philadelphia?
100%, very similar. I remember this was several years ago when I was externing still in law school. There was a man who had 2 sons, and one son, he worked with one son and he did a hobby with the other son. He owned a garage, like a junk kind of garage. And he worked with the son at the garage, like actually, scrapping metal, doing the junkyard work. And the other son, after the garage, like the business was closed, he'd rebuilt custom cars with the other son. So he, had a relationship with both sons, and he passed away. He had a garage of like 1959 Mint Mustangs that he had built over the course of his life with his son. Like, they built cars together. It wasn't for money, but as a hobby, as a pastime. And then he has a garage, I think, 10, 15, 20, like, all of these like Mint, 1969 Chevys, he rebuilt all of these cars. And then the 2 sons are, it's in a battle to the death over these, this very valuable item that the dad didn't say who gets what, right? Like, and then now it's made their life more complicated and it's wasteful.
I see it all over, repeated over and over and over again. And I remember when the first vaccines came around, my wife was a high risk. She was a teacher. And there's this huge church. When I say church, it was like a mall. It was so big. Not so close to our areas. It was a bit of a drive, but in central LA. And they had like 10 or 15 rows of cars lining up to get ready to get the vaccine thing or whatever. It was this whole thing. I said, you know what? I wonder if we could get attorneys and have word processors, printers right there, and just have people come up, give me information, input the form, print it out. Here's the notary, sign the thing. We could do like 500, estate plans in a day and transform the whole community. And I said, I'm gonna go pitch the pastor that one. And I would think he would be on board with that because the default would be he gets a piece of the deal. And but I don't know.
So this is like, I might get in trouble for the state bar from this one. This was something I really thought about, right? Like giving this recommendation. 100% get a lawyer, see a lawyer, right? Have a skilled scrivener write you a will, right? That's the advice I leave for everyone. But if you don't, too often people think they let perfect be the enemy of good, right? And what I mean by that is if they don't have a lawyer, they can't do a will, right? It's so often, more often than not, just having something, right? Like having some, it will have some sway in the future. It might not meet all the elements of a will. It might not have, the notary, or might not have the testamentary capacity necessary. But I assure you, any judge worth their salt that's looking at a person who died who wrote something in their own hand, right? It's verified, or that there was other people around that knew that they wrote this thing, even if it doesn't meet all the elements of a will, it will instruct the judge in which direction to go.
Yeah.
And too often people leave other people directionless because they're like, well, I don't have a will written by a lawyer, notified by notary, witnessed by 2 other people. I shouldn't do anything, right? So I am hesitant to tell people to do something rather than nothing, and it will be helpful.
Interesting. I tell people to do something better than nothing. I guess I run the risk of being accused of practicing law, but I mean, I guess.
The flip side of that is, right, like, oh, I went, like, this person thinks that they went and did that and it's enough, right? Like, oh, I listened to this guy and I went and wrote something down on a piece of paper and now I'm good, right? Like, that's not the idea I want to get across, but I'm saying that's better than not. If you're in a bind, if you're in a pinch, if you have nothing, if you want to take 10 minutes and write something down, and then next week plan to go see a lawyer to make it official, to make it better, right? Like that's what I would recommend. But too many people think that, like, if I don't have a lawyer, I can't have anything. And I would argue against that. I would have something rather than nothing. And then after you got something, go get something better.
Well, I would say 95% of the time you're better for something rather than nothing. Right. So just play the odds. Yes, there are 5% of people who will come back and say, see, I was worse off. And I've seen that. I've seen wills that were worse, and then they're now litigating the will instead of dying intestate, in which case things are distributed differently. I understand there's the outliers, but at least 95% of people are better off with anything rather than nothing, I think, as a general. And then once you get anything, then the next step is go see an attorney and get anything turned into the best thing. That's the whole goal of this.
Yeah. No self-interest plug there, I promise.
Well, yeah, you can't practice that, and I'm not practicing law, and I'm really living in Philadelphia.
So I can write a will, right? Like, I can scrivener. I can't, like, if you're saying, I think this will was improper, I want to, open the estate. That's what I can't do. So I can, if I get permission from my judges, I can sit with a woman and write her will, right? Like, that's not a matter that will come before the court, in the sense that there will be a conflict of interest. So I can practice, like, I can draw up estate documents. I can, make a trust. I can do those things. It's the, like, when anything that requires a court filing, like reconforming a deed, or actually, challenging a will, the validity of a will, or, saying that someone needs to be adjudged incapacitated. Those things are items and like I am a hard stopped from doing, right? But like the soft matters of sitting with someone and writing their will, that is encouraged, actually, because that's going to make me a better lawyer and better understand my craft.
Sure. So I know these numbers change from time to time when you have multiple courts, but in your court today, from the initial filing, what's the date to get an initial hearing? Is it 30 days? Is it 40 days? What's the initial hearing date today?
Well, in the Pennsylvania rules, right, when you file, let's say, a petition for citation or a petition for, let's say to appeal a will, right, there are a couple different mechanisms that trigger, right? So the first thing that triggers is the ability for someone to respond, right? So after you've notified all the parties, they have 20 days to respond to if they want to say, I object to this. So that's the first thing that would, before a date would even enter the mirror, is that time lapse has to happen, whereas they are afforded an opportunity to respond to the petition. So after that window has passed, then we are, typically it's another, I would say, somewhere between 20 to 30 days for a court to issue an order, right? So if it's, we filed something, 20 days has passed, nobody's responded, it could be another 10 or 15 days after it's come to the court's attention to say, okay, we will now issue an order directing what you've either asked or denying it, right? And then, I would say after you have filed something, it's safe to say within 3 months, there will be a court date.
And the court date is when the actual authority is issued, the letters of authority from the court.
Well, the letters of authority are issued immediately once. So if you go to the register of wills and you have the will and you have all the proper documentation, they will like post haste issue the letters testamentary, the letters of administration. That happens quickly. It's
Wow.
the filings with the court are the matters that are contested. So the register
Oh,
of will
wow.
will issue those quickly, right? Like a couple of days, just like you had mentioned earlier. The judges aren't the ones that grant the letters testamentary or the letters of administration. We deal more so with the contested matters than the what I would call administrative matters.
So if somebody thinks they've inherited a house, they can file the petition for the probate, get the letters within a few days, and then sell the house right away?
There are, I mean, the register of wills have their own procedures of notice, right? Like you have to, I mean, if people are going to do fraudulent things, right? Like not put all the interested parties in the when they're getting the letters of administration or testimony, right? That, nobody can help that, right? But in there, I mean, I think in my opinion, it will come to light sooner than later, because if you sell somebody's house and they're like, hey, what happened here? How did this property get sold? They can start tracing it back, right? And then once they come back to the register of wills and see that they were not added as a potential beneficiary
Oh,
or
wow.
interest or someone that was given notice, right? Like it will cast aspersions on the person who had letters testamentary or administration. But yes, it is a one-sided procedure in the sense that, like, I have a will, I have a copy of the will, I go and probate it, right? I go and take it to the register of wills. I
Wow.
announce that I have the will. They'll publish it. They will, issue the letters, and then the person with the letters, I mean, they have to do certain things, right? They have to file an accounting, right? So they have to file an inventory. They have to do certain things. But yeah, it is pretty like where you went immediately is someone can get the letters and someone can sell the property in due course. Yes.
Wow. Because in California, it's you can file and you're gonna get a court hearing in 30 days. And then so you may not need a hearing call if the paperwork's done, everybody's noticed, right? Then you're gonna get issued the letters, but there's at least a 30-day period, no way around it, before you get the letters of authority. So you can technically sign a contract. You can sign a contract, it's just not valid at that point if you're representing the state. So it's a little different.
That's speaking of the signing the contracts that aren't valid. I think in your area with real estate, particularly, I've noticed that this happens a lot. And I understand why it happens, but it feels a bit slimy to me that a lot of property deals are closed before there are the estate has authority to either sell the property or the person has gotten the letters
Right.
finalized. There are a lot of I've noticed that happens. And it raises an eyebrow for me when I see these properties have been, there is a sale pending, right? It's like,
Right.
how do you know, what I mean? I always see the sales pending, and I'm just like, I think to myself, what if we had denied this, right? Then what? What happens to your sale then, right?
Right. Well, if you know you're why I tell people, if you know you're legitimate, I literally this morning I had some of my team, and they were asking what they could do. I said, well, you can't really sign a listing agreement because technically they're not authorized to sign it. You can get them to sign it and tell them, we as a company say, we'll disclose to you the contract's not valid. This is going to be the same contract once you have authority. We're going to re-sign it once you have authority. But at least it spells out our terms and our agreement of what we're going to do. We help them get authority. Once they get it, we have to re-sign it. We can also have a buyer in the wings if you're in a hurry. You can have a buyer, but the buyer also has to understand nobody's approved to do this. So we're all assuming we're all going to work together and this is going to be fair for everybody.
I think it's particularly relevant now because the real estate market's so hot. Like it is.
Yeah.
I mean, people are paying, 100,000 over asking,
Right.
without even it's. I think
Right.
particularly because people are trying to lock down real estate now, that I find those deals, more and more frequently, those that items are contracted to be sold where people don't necessarily have the authority at the time that they've contracted or entered into a quasi contract to sell the property. Where because right now, like, the space is just like. I mean, you can't. Days. I've seen houses go up in for sale in like 3 days. They're sold.
Yes.
I'm just like,
Yes.
it's mind-boggling.
Yes. Well, look, I mean, to your point, you could pay 100,000 over asking. If the seller can't sell it because he has to go through probate, and I approach and say, look, I'll pay you 50,000 over asking, but I'll pay you your $10,000 attorney's fees, and I'll pay for all the court costs. So it only cost me 60,000. You're getting 50,000 over the asking price. I'm covering all those costs. I have some expertise. And frankly, that's what I do. I have some expertise to make this work. A normal In fact, my team member, this was a case where her client interviewed her to list a property, chose somebody else because he had a relationship. Well, that somebody else never checked the preliminary title report to know that the person living only had half interest. The other half interest was somebody who deceased. This person would be the heir, but that doesn't work in California. You still have to open probate to make that happen. So what I said to her was, well, he finds us a contract with us. We'll handle the probate. We have a service we refer to. And once he's approved, then we'll have the ability to list the property. The other agent could do the same thing. They just don't know that's all they have to do. They assume he's not authorized. I'm going to cancel the deal. So it's really about, in this case, serving our customer. The customer wants to sell the house. He's elderly. He's under stress managing the property, and he really wants to just get cashed out and move, and that's his privilege. So what do you must get in your world, family, friends, social people who know what you do and they're in the midst of it, but you can't really advise them in Philadelphia like an attorney to go to. But I'm sure you also get people, family, friends who are in outlying areas that you are. What do you typically or most commonly come across, and what do you advise friends, family members, social members who they have somebody who passed and they need to know what's the next step? What do you typically refer them to do?
I would recommend that they read Google reviews on certain attorneys, right? Like look for people who practice in that particular space. So just don't get, X, Y, and Z general practitioner, but people who are, there's always we're the probate lawyers, right? Like make sure they get the people who are in the space is one advice I'd give. And I also like, keeping meticulous records and is another thing I'd advise. Too often we see people mishandling estates because they just don't keep good records, right? Yeah. So they're when a judge asks for certain things, they can't come up with it, and it just doesn't bode well. So keeping meticulous records, making sure that they reserve their rights and they think critically about what that means, and because sometimes people don't understand what it means to like open a probate or to do things, right? Because sometimes for instance. Right. If you're staying in a property that belonged to your parents, right. And there is I remember particularly one woman there was a deed that had a conveyance, not a conveyance. It had a clause in it that prevented that right of reentry for someone else. And she wanted to put the title in her name. And I'm like, well, if you do that, right, like you give them that when you transfer, you give them the opportunity to purchase it at that point. Right. So just keeping it, like making sure that you have good advice and are going through the motions, knowing it intentionally, not just like knee jerk, right? People are like, well, my X, Y, and Z passed. I have to transfer the titles. I have to do all of the go through the motions but not doing it intentionally, right? There are tax benefits to doing things a little bit later, like knowing that where you're at, okay, well, if I do it now, I'm going to have a huge tax burden. Well, if I do it next year, maybe I can offset that tax burden by investing more or buying property or doing things in that calendar year that will offset this huge tax burden that, I now have if I transfer the state funds to myself now. So just doing things intentionally, making sure they have a plan, making sure they have counsel who's sound, who knows the space, that aren't just, good lawyers, but good lawyers in probate. And then I also, like, you're right, I sometimes get family members like, can you write my will, or can you do all these other things for us, or can you handle it? And I'm very cautious, right? And I want to help my family, but at the same time, like, I might not be the best person for them, and I recognize that.
Got it. Well, look, first off, I look forward to when the day comes that you announce that you've opened your probate focused practice. I certainly hope you would reach out to me, let me know, so we can announce to our group, our tribe of experts in the probate field in the Philadelphia area. In the meantime, you have a practice of law outside of probate. If somebody was interested in talking to you as an attorney on some of those other matters, how would they get a hold of you?
My email, which I'm, it's Andre Desir. It's my name, AndreDesir @gmail.com. I'm a millennial. We answer emails. We're always on our phone in our emails. So that I think is one of the best ways to get a hold of me. I'm on LinkedIn at Andre Desir if anybody wants to connect. That I think LinkedIn's another appropriate, millennial avenue for finding good folks. So I've handled a couple of, I think Bankruptcy, I've actually done, I don't know how I've found an interest in bankruptcy, and I've managed to do a couple bankruptcy cases, and I don't know why, it just comes naturally and easy to me. I think there is some connection between the work that I do, daily and bankruptcy, the bankruptcy code.
Right.
It's also about fairness. Ultimately, it's about making sure that people keep their, their houses and dignity sometimes. So yeah, bankruptcy is another area of the law that I've found has come naturally and easy to me.
Very procedure focused, I think both of them, as
Yes,
opposed to litigation,
very.
which is maybe more personality focused. Well, look, I sure enjoyed our time together. I could go on for hours. We've gone a little longer here than I might normally, but just on behalf of everybody who watches, I want to thank you for educating us. I want to thank you for the work you do on behalf of the citizens of Philadelphia. And just personally, I really appreciate our time today. So thank you so much, Andre.
I appreciate it too. Thanks for